and welcome to The Sage. I'm Paul Karlitz, CEO of Sagient in Los Angeles. I'm joined today by Andrew Marin, Esquire, to have a brief discussion on the basics of estate planning. We'll start with Andrew. Tell us who you are and how you got here.
I'm pleased to be here, Paul. This is very exciting. My name is Andrew Marin. I'm a California estate planning attorney and director of advanced planning here at Sagient.
What is an estate? We've kind of all heard the term, but it might be good to demystify it for everybody. What is an estate exactly?
Yeah. An estate is everything that you own, all of your assets that you have. And estate planning means different things for different people. So as an example, if you have minor children, part of your estate planning will consist of getting a will so that you can nominate guardians in the event that you can't care for your children yourself. With that, you will designate how funds should be spent and then perhaps any aligning values that you might have. For others, it might be that they have a special needs child where they're going to put a trust in place so that any inheritance wouldn't go straight to the child and kick out any government benefits that they might be receiving, otherwise getting the money to themselves. So as a buffer through a trust, you can avoid that.
There is a difference, I think, between estate planning and estate tax planning.
You nailed it. It's pretty polarizing these days. However, it's pretty simple. In fact, everybody can benefit from an estate plan. You don't need to have a certain amount of assets for it, because things like a power of attorney, which will designate somebody else to act on your behalf if you can't do it because of a mental or physical incapacity. So that's part of estate planning. Additionally, as we had mentioned, nominations for children. However, a certain group of folks have estate tax planning needs, which means that their amount of assets is above the amount that the government will allow to pass free of taxes. And that can be the number is met today or sometime in the future. An example would be a younger couple that may have an estate under the $13.6 million today, but looking out decades in the future, they may have an estate tax problem then. So what we can do is identify some strategies to implement today to offset some of those taxes.
So in almost layman's terms, it sounds as though everybody should have some type of an estate plan. It might be very simple for an individual or a young family without a lot of assets, but they still want to have control over what is theirs and where it goes. And then ultimately, if there's that 1% that we hear our politicians griping about all the time, that portion of estate tax planning is really a kicker around almost generational wealth. And I know we're going to talk a little bit later about the wealth transfer that's coming and where this might be really playing into those cards. How does an estate work within someone's their own financial plan and maybe their financial ecosystem, which I know is a weird word when we're talking about finances, but I think it captures the essence of overall planning and overall conversations when it comes to estate planning or estate tax planning.
The primary estate planning vehicle has become what's called a revocable trust. And we'll get into some more of the details around that. But the top areas are you can set control for your assets while you're alive and afterwards. It's a private document and it avoids probate. And probate is a very tough place to be in California that many people find themselves in. One of the things that I see as far as an ecosystem in a failing transfer would be do-it-yourself documents that ultimately don't achieve whatever purpose it should be. So an estate plan is about transferring the things that you want to the people that you want at the time that you want. And probate takes all of those things away from the individual doing this and puts them into the hands oftentimes of the state that you're with. So we see DIY documents failing quite often. And that's one thing that I would encourage individuals to look at their own financial situation. If they have documents, see if they're updated, see if the people that they have nominated are still the right people to do those jobs, and then make any adjustments as their situation changes over time.
Oh, terrific. There's a lot that goes into this, obviously, and we see a lot of people that, whether they work at a large company or a small company, there are benefits that they get at their companies, things like health insurance, maybe their 401k, there are typically insurance options. How do those coordinate or integrate with their overall with their estate planning?
As far as certain benefits go, let's talk about how certain assets will pass. Certain things that have what are called beneficiary designations, like a 401k, a life insurance policy, these things are oftentimes not titled in the trust because a fancy term, operation of law, just means that by the mere having somebody's name on the document and then the person primarily involved passing away or being incapacitated, it automatically transfers to that named person. So what we see is that those certain assets should be maintained oftentimes out of a trust. Now, everything else you would want to have governed by that trust should be taken into the trust by what's called retitling. So, a home, for example, would be changed from my name as an individual to a trust. Similarly, any benefits that you're receiving from a company, you might want to do that as well. But I would advise for certain accounts that have, again, what are called beneficiary designations, that you see if it might not be better for it to transfer that way as opposed to in irrevocable trust.
All right. Based on what you might own personally and through your company or however that's, is it possible to have more than one estate?
So the answer is no. You have one estate, and again, it's everything that you own. That estate will be compromised and composed of community and separate property. So you'll have one estate made up of those two different things here in California, community property state. But it is possible for you to oversee somebody else's estate, named as an executor in a will, for example. You would administer their estate. You can also inherit somebody else's estate. So a parent leaves you an asset or leaves you everything at death. It's not that you now have two estates. It's that other estate is joining yours.
It sounds like this could get really emotional, right? Especially families. I once heard a great phrase that stuck with me forever is there's no hardball like family hardball. So how do people maneuver through this without hurting somebody's feelings or the fear of hurting someone's feelings? And when that joins them, that makes it into their mind's eye, they throw their hands up and say, forget this. It's going to be too difficult. So-and-so's not going to be happy. And it's just easier I'm not going to be here anyway, so who cares?
Yeah. It's a very common thing that we see. And when we have clients that we're seeing sort of spinning the wheels and having one of these solutions, what we'll do is we'll explain to them the consequences of inaction. So if they were to have passed away yesterday and nothing was planned for, what would today look like for the ones that they love? And oftentimes that loss of control, some chaos, or perhaps people getting distributions at times that they shouldn't, will get them to start moving. One of the main things about having a trust is that it's private. So when you set up a successor trustee or the person that's going to take over afterwards, or when you nominate that person or you include beneficiaries and say who's going to get what, nobody will see any terms of that trust until you allow it or until after you're gone. So the privacy factor is there the entire time, and the weight of planning is lifted off your shoulders. So I would say the real concern of offending somebody by planning is not really a concern in the sense that they're not going to see anything that you're doing, the people that one would be concerned about.
Is there two parts? Is there the concern might not be that they see it happening, like you're saying, because it's private. I could see someone having a concern, well, all of a sudden, now I'm not here. This has been dropped on them. And now siblings, cousins, spouses, now they're looking at each other. So is it common practice to try and bring everybody together in this process? Or is it, hey, it is what it is, it's done, and now all of a sudden they find out? Because I would imagine if you can get everybody together and on the same page and hearing the patriarch's wishes, assuming that's the situation, and understanding it, they might get a little uncomfortable then, but at least it's on the table and it's done, versus now there's a grief period, a bereavement period, and while that's happening, all of a sudden, wait, Susie got more than Billy, or something along those lines, or wait a minute, I thought we were getting X or Y, and then there's conditions put on that they didn't expect. So in leaving that might be a source of difficulty on either side of it. How do you kind of maneuver that?
Yeah. Well, as with always, a good starting answer, it depends. And it really does depend on the family
Spoken
dynamics.
like a lawyer.
That's right. It depends on that family dynamic. So if you have matriarch and patriarch that have been sort of dictators the entire time, then, sort of that ruling fist is what everybody expects. But if there are going to be uh, things in the trust that we will call unequal distributions. For example, you have three children, two of them are very successful, and one of them has some sort of disability or handicap. Well, it might be that the parents, knowing that or confident that their two stellar, successful kids are going to continue that trajectory, they might leave those kids less and leave more to the child that has more of a disability or a need for that money.
I'm
So
picturing the TV show Succession. So,
that is exactly right.
so I'm like, that was uncomfortable. There was a lot of discomfort in that.
Yeah.
And obviously we don't live in a TV world, but that, I imagine some of that emotional issues that they had resonate with everybody.
Well, these TV shows are often based on real life events,
Mhm.
at least parts of them. Certainly, having a conversation saying that one of your children is getting more than other children and having to explain that and maintaining face and maintaining relationships, can be a difficult conversation to have. But as you point out, sometimes it's better to have now than later. Or
What happens if you don't have any kind of plan in place and there's just nothing?
so it's different rules for different states. But in California, if you pass away with no estate planning document, then California is going to use their intestate laws to say where the stuff goes. If you have a will in California as your primary estate planning document, that's going to go to California courts to be validated, and you're still going there. If it doesn't name proper beneficiaries, the court is still going to determine it. So I'm saying all of those ways to get there because it's important to leave our legacy intact, to leave it uncomplicated and efficiently transferred timing and without taxes to the next generation. So, not having an estate plan, you're going to set up the ones that you love to go to court and perhaps battle among each other for who gets what.
You kind of hit on probate there a bunch.
Yeah.
Maybe what is probate and is it that bad? Why do people want to stay away from it?
Is how do we avoid probate? Well, that's making sure that we have under $184,000 of assets in our name this year at death. So another way of putting that is the state of California allows for people that passed away with $184,000 or less of things titled in their name. So this would be your bank account and your investment account is all you have, and the total of that is $100,000. One can take what's called a small estate affidavit, which is just a piece of paper that you write on and say the person that passed away had under this amount, the threshold amount at death, and I can use this to go get access to that money as the next of kin, let's say as a child for a parent that's legally entitled to it, without having to open up a probate to petition for that asset. Again, only if it's under that threshold, which is called a small estate affidavit.
Okay.
Now, straight into probate, which is a very, very unfortunate place to be in California. I'll start with probate is different in different states. In some states, probate is the primary estate planning vehicle because it's cheap and it's fast. In California, it
Not so
is
much.
devastatingly expensive and time consuming. And so probate is the legal process of getting your assets from yourself after death to where it should go. And it can be determined where it should go through a will, which is a wish list to a judge that you take before a judge or your family does. The judge validates it and gets you your things. But a will is going to probate. Similarly, without a will, the court is going to look at you, look at your estate, look at who's alive to inherit your estate, and then look at the state of California laws and say, well, it should go here. And then as a family member, all you can do is just wait in line and oftentimes hire a lawyer. Or if you are a confident individual or a glutton for punishment, you will not hire a lawyer and do it yourself, which is certainly a way to do it.
You
And
mentioned DIY before, and it's not such a good idea.
so probate is a bad place to be in California, and there are great ways to get around it. One of the very easy ways that I'll mention is to have a revocable trust. You have a trust that moves everything out of your name and into this trust, into this legal box, and you can change it. You can update it. You can change who gets what and when. You can take things out. You can add things in. So anything in there will avoid probate. Another way of doing it is with titling as joint tenants, which is a term that you might have heard. So if I own a piece of property or I own an asset, I own it as Andrew Marin as an individual. If I bring Paul Karlitz along because I want him to join in on whatever this asset is, we could title it as Andrew Marin and Paul Karlitz as joint tenants. Unfortunately, many people think that this is a fail-safe way to avoid probate, but I'll highlight a quick example of how that could go wrong. Let's say we have parents involved in a car accident. Husband dies immediately. Wife survives for 10 minutes and then passes away. All of parents' assets were owned as joint tenants. They didn't have a trust. They didn't have anything else. So let's think about this. At the passing of the husband, everything by operation of law, because it's joint tenants, automatically went to the wife. Upon the wife's passing 10 minutes later, everything was held in her name. So everything that she has in her name must then go to probate. So you can see an example. If you own an asset that's joint tenants with right of survivorship or joint tenants, and both people pass away within a certain amount of time of each other, it can fail for the terms or purposes that you want it to do, which would be avoiding probate.
So because it was such a short period of time, that 10 minutes, even though it was in the same car accident, there is no simultaneous, so to speak, where it would just skip maybe the person who died a second later. Is that?
Yeah. So it is certainly can be thought of that way. Another way I want to think about it and present it here is when one person dies and let's say husband and wife, husband dies, everything goes to wife. Now wife owns everything in her name. And if she does no estate planning, whether it's 10 seconds later or 10 years later, everything in her name is going to have to be, the children rather, will have to go to probate to get everything out of her estate upon her passing.
Okay. There's estate planning, like we've said, which is just some of these basics. And then the estate tax planning really takes place because there is no estate tax even considered until a second death. Is that, maybe you can walk us through that?
In the United States, it's called the unlimited marital deduction, which means that for married couples, upon the passing of one, the other person has to pay no taxes on that individual's passing. So everything that was owned by the first person to die will go to the second surviving spouse with zero taxes.
And is that both estate and state taxes?
It's a great question. So that is going to be for the federal side of things. Unlimited marital deduction is federal, and because it's a federal law, the states aren't going to be able to counteract that and say, you can't do that in California. As a matter of fact, we're going to tax on the first half. One of the things, though, that the United States does is not necessarily out of the goodness of their heart that they're doing that, because on the passing of the second spouse, there's going to be estate taxes due. So it's not like we're avoiding the first half out of the goodness of our heart being the United States. However, it's going to be that they know that the second spouse is going to pay taxes on that. One thing I want to just kind of loop in there for anybody that is listening with a foreign national or a non-U.S. citizen spouse, it doesn't apply. Doesn't apply. So that first spouse is a U.S. citizen. The surviving spouse is a non-U.S. citizen. You don't get that marital deduction there. And the reason behind that is because the U.S. is concerned that upon the passing of that U.S. citizen spouse, now the second non-U.S. citizen has all of the assets. They could just move from the U.S. back to the home country and not be taxed on any of that stuff.
What about the inverse?
Anything into the United States is non-taxed.
Okay.
U.S. says, bring us all of your assets. But on the way out,
Right.
You're getting taxed.
what's yours? What's mine is mine, and what's yours is mine.
Not just in marriage.
Does it matter if you're 20 or 50 or 30 or 70? As far as estate planning or estate tax planning, specific to age, obviously, we've already identified that it's based on situation, but the situation of a 30-year-old, if it somehow is the exact same as the situation of a 50-year-old, does that mean planning is done differently, other than maybe considering life expectancy based on the ages? But is the planning any different?
I'm glad that you asked the question. And the answer that it is, it really is. So let's consider sort of young, middle age, and then older age. So for a young person, let's call them 20s. It's important to have what we call living documents. These are going to be your power of attorney and your healthcare directive. Now, it's important to have these in place as a young 20-something, because let's have an example of you are in college in a foreign state and something happens to you and you're taken to the hospital. Mom and dad fly out to that state and try to come in to visit you. Well, many hospitals will not let anybody in unless they have a document saying that they're authorized to be there, because the healthcare director or the people at the hospital, they don't know the relationship between father and child or mother and child. They don't know the dynamic. So without a power of attorney, without a healthcare directive, it might be that you have to petition a legal process to go and have any authority over that person. So I would say no brainer having those living powers for a young person. Now let's talk about somebody in their 30s or 40s. Perhaps you're starting a new family, you're buying a new home, you're having a child. You are going to have reasons to start implementing new estate planning vehicles. The first one would be a revocable trust to own your house. This is going to be to avoid probate, to manage your funds and everything else should something happen. The next one is going to be a will. You need a will as a parent with minor children, because that's the only place that you can nominate a guardian to raise your child should something happen to you. And I would also say, as an estate planning tool to make sure that there is enough in the estate to carry out a person's intentions, would be to ensure for what's known as human life value. And human life value is a calculation that was put together, unfortunately, after the advent of the 9/11 attacks. And what it says is basically somebody's insurable interest, or the amount that they can qualify for insurance, is based on their age, based on their income, that income going up with inflation, and then their overall work expectancy. So a 30-year-old making $50,000 going to 65 versus a 30-year-old making $500,000 going to 65 is going to offer two levels of insurance. So I give that background story because when we do estate planning for younger couples, oftentimes there isn't that contingency in the event that they're either disabled or, God forbid, they pass away young with a young family. And perhaps they're the primary breadwinner. So in order to assure that their estate planning objectives are seen through in the event that they may not be able to produce like they would, having that is a great way to make sure that these plans are funded.
You hit on a couple of terms there. I know there's a lot more, but maybe we can do almost rapid fire. I'll give you a term and you can define it.
Great.
Guardian and alternate guardian.
So a guardian is where you name in a will somebody to care for your child if you can't do it for yourself. An alternate guardian is a person behind them if they can't do it. One important thing that we see is that people will come into the office and they'll say, I want Paul and Jeannie to be the guardian of my child. Important note, it's only one person at a time. It can't be couples that are nominated.
Oh, that's interesting. Yeah. Okay. Trustee and successor trustees.
So the trustee is the person that is overseeing the trust and has a fiduciary relationship to the trust, which just means a legal standard of care that they have to provide to oversee the assets that are inside of this trust. So the trustee oftentimes is the person that sets up the trust while they're alive. The successor trustee is the person that they nominate either upon a triggering event like an incapacity, or they give them the authority by saying, act.
Okay. What is, I feel like this is a Jeopardy question, what is an executor?
What is an executor, Alex?
Exactly.
Yeah,
For 100
200.
points. Yeah.
So an executor is the person named in a will that is going to oversee the administration of that will. So this is the person that you have named to take over after you have passed away to make sure that your wishes reflected in that will are seen through.
So it seems similar, and I'm sure to a layman, what's the difference between an executor and a trustee?
That's a great question. So an executor is only a term for a will. Executor, will. Trustee, trust.
Got it.
So it's the same. You can think of it as the person in charge can be the trustee or the executor. And it's oftentimes the same person if both of those documents exist. And I'll give you a quick example of how that might work. You name as the successor trustee this person. Within your estate planning documents is known as a pour-over will. And a pour-over will is effectively a wish list saying that anything that I had titled in my name when I passed away, I want you to transfer to my trust so that it avoids probate and it gets distributed by the terms of that trust. So you can have a trustee, you can have an executor be the same person, and within your estate planning documents, oftentimes you do.
Okay. And continuing with our lightning round of topics, healthcare proxy, and then maybe dovetail that into power of attorney.
A healthcare proxy is going to be more important as people are living longer and longer. And a healthcare proxy effectively has you nominate another person to act on your behalf because you can't due to incapacitation for mental or physical reasons. Now, in this healthcare proxy, you are effectively making the decisions now for a future event when you can no longer express those wishes. And the agent that you have nominated really only goes through and follows it like a checklist all the way down. It's so important to have, and I'll give you an example of what made headlines and really brought healthcare powers to the forefront in the early 2000s. You may have heard of or remember a case. The gal's name was Terry Schiavo.
Yep.
Terry Schiavo had, for about 10 years, been intubated, where she was hooked up to a hospital bed, basically, nonverbal. And doctors had said that she was in a persistent vegetative state, meaning that they don't think that she's going to wake up. She didn't have a healthcare power of attorney, and her husband wished that they pulled the feeding tube and basically took her off life support. Her parents, still living, said no, and they wanted to keep her on life support. There was a huge court battle between those two, and everything was public and drawn out. Had Terry and her husband created a healthcare power of attorney before this, the doctors would have looked at the document and made the decision based on her recorded wishes.
Okay. Power of attorney?
Similar to a healthcare directive, a power of attorney is you answering questions about your finances and appointing an agent to go through that for you in the event that you can't do it for yourself because of a mental or physical incapacity. Okay. So this is going to be, for lack of better words, somebody keeps the lights on, somebody keeps the bills paid. They have the authority to transact, to go into your bank account, and to make sure that that nobody is going to foreclose on your house when you are laid up in bed.
And I've heard the term living will. Is that different than anything we've hit on before?
You may have heard also of living trust, living will.
Mm-hmm.
The living part of the will means that you have what we call living documents. Basically, there's a power of attorney and there's a healthcare directive that are built into this estate plan. Now, one more term I want to add to that is durable. Durable power of attorney, durable healthcare. If you just have a healthcare or power of attorney, it becomes, if you had it in place, it becomes unusable at incapacitation. The term durable means that it survives incapacitation. So you want to make sure that you have a durable power of attorney and a durable healthcare proxy.
It seems that's a very legal distinction, because why would you have it if the minute you need it, it's no longer viable?
Yeah, that's a great
Right.
question.
So,
And some people have powers of attorney that they're using for a particular reason at a particular time, and
okay.
they want it to expire upon their
Okay. So that's the
expiration.
differential. Okay, great. Um, we've hit on estates, trusts, wills a little bit. Maybe you can define a trust and why it's used. Is it an income tax play? Obviously, it's part of an estate tax conversation. Why would somebody want to set up a trust? You mentioned revocable trust, but what are your thoughts on all of those?
Yeah. So let's define a trust first. And a trust is it is an arrangement to hold money for the benefit of another person. And so it's basically an arrangement between the person setting it up, that's known as a grantor or a settlor, and the trustee, which is the person that is managing the trust for the benefit of the beneficiary, which is the person that the grantor intended for things to go to. So it's arrangement between these three parties of the person establishing it, the person running it, and then the person for whose benefit everything has been set up. So the trustee is a fiduciary, which is a legal standard, which means a high level of care. So this trustee that somebody is nominating is going to be somebody that can't go in there and do self-dealing and do wonky stuff, because they can be held accountable for some of their actions in there.
Oh, I see we've gotten out of the technical terms with wonky. So
Got to be relatable somehow.
there we go. Right,
Every once in a
exactly. For the masses.
Yeah.
What does a trust actually own? Like it's a doc, it's paper, it's ink on paper. So what does it actually own?
Yeah. So a trust, think of it as a legal box. So this is a legally recognized box, and it only governs on the terms that you've created the things that you place into the box. So if you have a fantastic shiny trust that owns nothing, it was just an expensive paperweight, because those documents aren't doing anything for you. So you want to make sure that you put into the trust anything that you want it to be governed by.
All right. Sounds like it could get wonky. How do you use how do you use trusts with blended or nuclear families? Right. That's all. I imagine these things were developed long before blended families. So how has the law either been nimble or acknowledged or flexible as it relates to the whole new world? Blended families, same-sex families now is a whole new genre. I would imagine that when the founders came up with this stuff, those were not part of their conversations.
As the times change, so do the laws. And as we know, the laws are oftentimes very far behind the changes that we see in the environment. So to just hit on your first one of blended families, we're seeing this more and more now. And a blended family is essentially husband and wife were married before and have children from those previous marriages, and now they're getting married. And so you have these separate families that are now unionizing, that are now coming together as a union. And there may be children from that new marriage. So one of the complications that can arise, and certainly one of the stressors that we see with clients, is in the back of their mind, knowing that if everything is in a revocable trust, which means it can be revoked, changed, thrown away at any time, that after the passing of one of the parents, that the surviving parent might be sort of the fantastical evil stepmother that might, or evil stepfather, that might at that point say, I'm going to disinherit their kids and just give everything to my biological children, which I'm sure happens. I haven't seen it, fortunately, but it's a real concern. One of the ways around this that we've seen, which is pretty straightforward, is by creating and using a trust. This would be an irrevocable trust that the parent with that concern would fund with an amount of money that would be left for the children from their previous marriage. And then anything in their estate can be left to the new wife and perhaps the new children. So one of the ways that we see this not being implemented right away is because individuals don't want to transfer funds dollar for dollar into a trust. So one of the things that we've been able to see as a way to kind of move those clients that are wary of losing control of those funds is using something like life insurance, which costs dollar for dollar less than it would, and it provides liquidity when it's needed.
And so, do you put life insurance into trusts, into that shiny box that you were talking about a minute ago? Is it something that you mentioned revocable and irrevocable, and sometimes said quickly, people don't know the distinction. So irrevocable has IR in front of it and revocable doesn't. But maybe explain the difference, and what do you own in either version?
That's a great question. So think of revocable trust as revoke. That's the key word there.
Mhm.
I can revoke it, I can change it, I can amend it, I can terminate it, I can throw it into a fire and it's gone. But you only can do that when you have the capacity to do it. So that means that you're still able to transact on your own behalf. An irrevocable trust means that we have given up control of some of the asset by putting it in there. And an example of this would be transferring some of an estate into an irrevocable trust to lower my estate tax concern and allow the appreciation within that irrevocable trust to appreciate without being included in my tax. So I'll say that back as an example. If I have an irrevocable trust, I can transfer my assets to that trust and have some tax benefits in doing so. But the important thing to note is that I have to be willing to give up some of the control of the asset. And that's what allows the government to give me some of these beneficial treatments by doing so. One of the things that we see, and I'll just tie it up with this, for again, clients that know that they should or might but don't want to, is by using what's known as a grantor retained annuity trust, or using an irrevocable trust where you can have an income stream come back to you. So an example would be if I transfer a $1 million house into an irrevocable trust, and I'm concerned about losing all of the control and all of the money coming off of that property, I could structure an interest-only payment to myself to have some of the money come back. But then appreciation of that asset will be removed from the estate entirely. So it's a complicated piece, but there are benefits of having that irrevocable trust in place.
So thank you, Andrew. I thought this was a terrific conversation. We clearly covered a lot of ground. And thank you for watching The Sage. Again, I'm Paul Karlitz, the CEO of Sagient, and this is Andrew Marin, Esquire, also of Sagient.